Hello, I'm Michael Henderson, legal counsel with the Administrative Office of the Courts. I'm going to be talking about legislative changes, some legislation that was enacted this year, and changes in business practices and implementation of those changes. The report on uniform business practices and implementing those changes is really very thorough. The people who put it together have done a very good job, and it really provides a lot more detail than I'll be able to give you. So I'm just going to be going over the 7 statutes that are referred to, the 7 bills that are referred to in that report, and just giving you some outline. First of all, House Bill 494 as amended. This deals with underage alcohol offenses. The objective of this was to change some of these misdemeanors to infractions to lessen the impact on young people who have first-time violations for possession or consumption of alcohol. But at the same time, there was concern about not reducing the revenue that would come in from the fees that are attached to these offenses. So what this bill does is it amends 18-1502. It makes first-time underage alcohol violations under sections 23-604 and 23-949 infractions rather than misdemeanors. And again, that's only for first-time violations. It imposes a fine for those offenses of $300. And it amends a number of statutes to provide that the fees that were in effect before, when these were misdemeanors, still apply to these even though they're infractions. In addition to that, the Juvenile Corrections Act has been amended to make these status offenses as well as infractions, and to provide that juveniles who are charged with these offenses shall be treated under the Juvenile Corrections Act. So with regard to business process relating to this bill, first of all, again, there's no change in the fees that are imposed, even though these are now infractions. You'll be seeing that the fees that kick in are the same as those that apply to misdemeanors. There may be a change for those counties that process first-time underage alcohol violations in magistrate court as opposed to juvenile court. Since these are being deemed to be status offenses as well as infractions, they should be handled under the Juvenile Corrections Act, which may mean going through juvenile court. The second bill is House Bill 495, and this deals with 18-1502 and underage alcohol violations as well. Even though it has the next number, 495 after 494, and deals with the same statute, it really originated with a different legislator, and it's just coincidence that they come together. This says that a person who has a violation of 18-1502 or 23-604, again, those are underage alcohol violations, can have that violation set aside if 2 conditions are met. First, it's their only violation of those sections, and second, they have no other alcohol or drug-related findings of guilt for the next 5 years after that first violation. It also provides that the violation, by which I think the statute means the file, is sealed by the court if the violation is set aside. And it states specifically that the person committing the violation must initiate this process. So with regard to the business process on House Bill 494, again, the violator must initiate this process of having the violation set aside. A form will be provided by the court for them to apply for that. No fee is charged for requesting that. If the order setting aside the violation is granted, then the order is to be served on the parties and on juvenile probation. And finally, the record of the case is sealed. The procedure for dealing that is set out in Idaho Court Administrative Rule 32, and it's also set out in the report on uniform business practices relating to implementing legislation. The next bill is House Bill 556 as amended. This dealt with foster care. There were a number of concerns about the movement of children who were in foster care from one family to another. There was concern about placement. There was concern about other procedures that the Department of Health and Welfare uses in these cases. The major provisions of the bill that came out are, first of all, if you have an adoption arising from a CPA action, from a child protective action, the permanency plan in that CPA case must specify the adoptive parents. If the parents who are set forth in the permanency plan are different from those who are being proposed as the adoptive parents, then there has to be an amended permanency plan naming those parents specifically. After adjudication, custody of the department is subject to judicial approval of all matters relating to custody if they're contested by any party. Foster parents with a significant relationship with the child have been added to the priority list for placement of these children. They now come after relatives and non-relatives with a significant relationship with the family, but ahead of other foster parents. And if the child's placement is to be changed after being in a prior placement in foster care for at least 60 days, the caseworker's determination to change the placement has to be approved by a supervisor. That does not apply in cases of abuse or neglect. Well, with regard to business practices relating to House Bill 556, what does this mean? Well, a couple of things. First of all, again, if the adoption arises from a CPA case, the judge is going to have to verify that the permanency plan identifies the adoptive parents. And second, with regard to this review of matters relating to custody, again, any party can contest a matter relating to custody, and it is then subject to approval by the court. Idaho Juvenile Rule 43 has been adopted to guide that review process with regard to how those are filed, the time for responses, and within 14 days after the responses have been filed, the court has to either rule or set a hearing on the matter. That is all set out within Rule 43. The next bill is House Bill 558. This deals with minors' compromises. These are situations where there is a lawsuit on behalf of a minor and there is a settlement. Those settlements have to be approved by the court in order to ensure that the minor's interests are being protected. The statute that deals with this is Idaho Code Section 15-5-409A. That statute has said that the parents can petition the court for approval of the minor's compromise. The problem is sometimes you don't have parents in the picture. They may be deceased. They may just be incapacitated. Parental rights may have been terminated. So what this bill does is it provides that the petition to approve a minor's compromise can be filed by certain other persons, and it provides an order of priority with regard to who gets to file the petition. First, conservators; second, guardians; third, parents; fourth, de facto custodians; and fifth, other legal representatives. This bill also amends the statute to require detailed information in that petition about the case and about the minor, so that the court can look at the petition and already have a good deal of information about the case, about the compromise, the settlement that's being proposed, and can make some judgment as to whether it should be approved. And finally, the statute requires a hearing if the amount of the claim is $10,000 or more. If it is less than that, then it's within the discretion of the court whether to set a hearing. And with regard to business process, that really is the main change. You'll see more details in these petitions to approve minors' compromises when they come along. But the main business process is with regard to hearings. Again, you must have a hearing if the amount is $10,000 or more. Otherwise, the court has discretion as to whether to hold a hearing. Senate Bill 1328A, as amended, amends several provisions of the Child Protective Act. The intent of this bill, which was drafted by the Child Protection Committee, was to make revisions to the CPA to bring it into conformance with federal law. And also, it was intended to address concerns about Indian children and protecting their rights and the rights of their relatives. And also, there was concern about the use of psychotropic medications with children who are under the jurisdiction of the court under the CPA. We've had reports of very high percentages of those children who are receiving psychotropic medications, and there was concern about whether that's justified. I'll go through some of these things rather quickly with regard to the business practices related to Senate Bill 1328. Many of these things are will not require changes in what clerks do, but you'll see some different processes, and it may make difference in what the court has to do, what the judge has to do in these cases. First of all, what used to be called transition to independent living is now called transition to successful adulthood. Planning for that must start at 14 rather than 16 under the previous law. Case plan has to document that the youth has been informed of his or her rights with regard to education, health, visitation, court participation, and the ability to get an annual credit report. For youths 12 and older, the court must inquire at review and permanency plans into the youth's permanency desires, where they want to be placed. Where adoption is not part of the permanency plan, the court has to find compelling reasons why other placements, other than those being proposed, are not in the youth's best interests. And steps have to be taken to provide extracurricular, enrichment, and social activities to those youths. The Department of Health and Welfare must make reasonable efforts to place siblings together unless there are reasons not to, and the court has to inquire as to the efforts that have been made to place siblings together. The department is also obligated to provide educational stability for these children, and the court, again, shall inquire about the efforts that are being made to do that. The court is also inquire as whether there is reason to believe that the child is an Indian child, and what efforts have been made to determine that. Those inquiries have to continue at each hearing through the adjudicatory hearing, and perhaps beyond that until there has been a final determination as to the child's Indian status. And finally, with regard to psychotropic medications, at every review and permanency hearing, the court shall inquire about psychotropic medications. And that information has to be provided to the court by the department. Now again, what you're going to be seeing in CPA cases is not going to be much different, but those are some of the changes that are required under Senate Bill 1328. The next bill is Senate Bill 1352. This deals with termination of guardianships. Curiously, there's a statute that provides for how you terminate a guardianship of a child, where the guardianship has arisen from a CPA case. However, there has been nothing in the statutes to talk about how you terminate a guardianship if it didn't arise from a CPA case. And this bill simply fills that hole in the law. It amends Section 15-5-212 to provide that any person who is interested in the welfare of the child, or if the child's at least 14, may petition for modification or termination of the guardianship on the ground that it would be in the best interest of the child. Again, with regard to business processes related to Senate Bill 1352, there's no real change. Simply be aware of it, and that you may see these petitions now that we have a specific provision in the Idaho Code allowing these petitions. One of the more significant bills with regard to what you're going to be seeing is Senate Bill 1373, and this relates to protective orders. Now again, we have domestic violence protection orders. You're all used to dealing with that. But this provides that persons who have been the victims of malicious harassment, stalking, or telephone harassment within the previous 90 days may petition the court for a protective order. The person against whom the protection order is being sought need not be a household or family member or a person with whom the petitioner has or has had a deeding relationship. So it differs from domestic violence protection orders in that respect. Otherwise, the procedures that are set forth in Senate Bill 1373 really track very closely the procedures in domestic violence protection order cases. With regard to the business processes related to Senate Bill 1373, as with domestic violence petitions for protective orders, there is no filing fee for filing these petitions. That's now set forth in the filing fee schedule under H2D. Amended civil protection order forms for these petitions and these cases have been prepared. Now, one of the provisions in this bill 1373 is that a person may seek relief in the same petition under both 396304, that is a domestic violence protection order petition, and for a protective order under this provision for malicious harassment, stalking, or telephone harassment. If that's done, the person has to set out the facts relating to each of those requests for a protective order. But you will see on the forms as they have been drafted that it actually provides for seeking relief under the domestic violence protection order provisions, under these protective order provisions or under both. So it's a little more complicated. Finally, one of the differences between these protective orders and domestic violence protection orders is that if there is to be a renewal of the protective order after a year, under these petitions, under these protective orders, there has to be a hearing for renewal. And that concludes the review that I was going to give you on the legislative changes. Certainly, if there are any questions, you can try to contact me or Cathy with any follow-up questions. We expect there will be. Some of these are significant changes in procedure, and we want to hear from you about any questions you have and also find out how these legislative changes are working out. So thank you.
My name's Cathy Dearden. I'm the staff attorney here at the Idaho Supreme Court, and what I'm going to do for you today is give you an update on all the rule changes for 2016. Some of the rule changes actually took place earlier this year, so I'll let you know if that's the case. The document entitled Highlight of the Rule Changes for 2016 is online. It covers all the rule changes. I'm only going to go through today the ones that I think you as clerks might be interested in or might have some effect on what you do. The only amendments to the Idaho appellate rules that I want to mention are ones that took effect on January 1. The rules pertaining to the filing of a notice of appeal, Rules 11, 11.1, and 17, were all amended to require that a copy of the order or judgment being appealed be attached to the notice of appeal. And the purpose of this rule is just so that we can know right up front that this is actually an order or a judgment that truly is appealable. However, if the parties don't attach that copy of the order or judgment, you should go ahead and file stamp the notice of appeal anyway, because we can remedy that later. The notice of appeal, the timely filing, is jurisdictional, so we want you to file it. On the Idaho Rules of Civil Procedure, on January 1, there was an amendment to Rule 54 on judgments. That rule was amended with a new subsection providing that if the court orders an amendment to a judgment, that amendment is not effective until the court enters into judgment that includes not only the terms of the new part, of the new amended portion, but the entire part of the judgment that remains in effect. So in other words, whatever's new or has been modified has to be incorporated into the earlier judgment. Subsection B of Rule 54 was also amended. That's the rule that allows a district court to determine that a judgment that is final only as to one issue or one party should go ahead and be appealed to the Supreme Court. The amendment to the rule reflects and clarifies that this is only a partial judgment, even though the judge is certifying it as final for purposes of appeal. On July 1, we have a new set of Idaho Rules of Civil Procedure that's coming out. The new set is a result of a special ad hoc committee that was chaired by Senior Judge David Day. It was charged with updating the rules. The rules have been reformatted. There's a new table of contents. The language has been simplified, clarified, and modernized. It's going to be much easier to work with. There's also a new set of rules for small claims actions. Some of the rules were obsolete and they were deleted. Some rules were moved to the Idaho Court Administrative Rules. And also there was a number of substantive changes that were made. The substantive changes went through the Idaho Rules of Civil Procedure Advisory Committee first. So I'm going to go over some of those rule changes. Rule 11 is the rule on signing pleadings, motions, and other papers and the representations you make to the court. You may be aware that when an attorney or a party signs a pleading, they are certifying that they've read that pleading or motion and that to the best of their knowledge, information, and belief, that motion or pleading is well grounded in fact and is warranted by existing law or is well grounded for a good faith argument for modification of the law. So if they impose it for an improper purpose, then that violation of that rule can be a cause for sanctions. The amendment adds language found in the federal rule on the procedure for a motion for sanctions, the nature of a sanction imposed under the rule, and the limitation on monetary sanctions. The rule also clarifies that a law firm may be held jointly responsible for a violation committed by a partner, associate, or an employee. In addition to the changes identified above, there's a new paragraph that adds that the court in its order must describe the sanctioned conduct and explain the basis for the sanction. Rule 16 is the rule on pretrial conferences, scheduling, and management. A new subsection was added entitled Request for Trial Setting by a Party. It allows a party to request the court to set the matter for trial and to set any other deadlines and conferences should the court fail to do so after all the defendants have appeared. Rule 43 is a new rule on taking testimony. The rule now provides that for good cause, in compelling circumstances, and with appropriate safeguards, the court may permit testimony in open court by contemporary transmission from another location. The language comes from the federal rule, and the commentary in the federal rule reinforces the importance of presenting live testimony in court. So the transmission can't be justified merely by showing that it's inconvenience for one of the witnesses to appear. The commentary also states that the most persuasive showing of good cause and compelling circumstances are likely to arise when a witness is unable to attend for some unexpected reason, such as an accident or illness, where they might be able to testify from a different place. Contemporaneous transmission may be better than an attempt to reschedule the trial, particularly if there's a risk that other or perhaps a more important witness might not be able to attend if they reschedule it. Rule 55 is on default and default judgments. References to the clerk entering default judgment were removed. So this change will require a change in business process for those counties that have allowed the clerk to enter the default judgment. This is now reserved for judges only. Rule 66 on sureties on bond. The language regarding enforcing a surety's liability that was formerly part of the rule on temporary restraining orders and preliminary injunctions was made into a separate rule for the purpose of making that applicable to any instance where surety gives security under the civil rules. The provision is that the surety's liability may be enforced on motion without an independent action. The motion and any notice that the court orders may be served on the court clerk, who must promptly mail a copy of each to every surety whose address is known. And again, this is not a new procedure for the clerk. It's just expanded to more situations. Appendix A on the filing fee schedule, we do have one or two minor changes. A request to modify support or custody under the Idaho Rules of Family Law Procedure may now be done by petition or by stipulation. The amendment to the fee schedule reflects this change so that the filing fee is required even if the request is initiated by stipulation. And remember, this is the initial filing of that request to modify. Please note that in the category H on the filing fee schedule, in case filings with no fee, under this section there's an entry for stipulation for entry of judgment. That no fee is meant to cover the situation where a plaintiff has paid a filing fee to initiate the action to modify or to reopen the action, and then comes back and the plaintiff is the one filing the stipulation for judgment. It's really the appearance fee for the defendant that's being waived in that case, or that's not being charged. The fee schedule now tries to reflect that clarification. So under subsection H, category H, where it says no filing fee, it says stipulation for entry of judgment after initial case filing or reopening fee has been paid. So again, if you initiate or reopen for modification with a stipulation, there is going to be a fee. On the Idaho Court Administrative Rules, as part of the effort to update the Idaho Rules of Civil Procedure, you should be aware that a number of the rules were moved to the Idaho Court Administrative Rules, including rules on jurisdiction and assignment of magistrates, the transfer of a case from magistrate to district court, reporting of proceedings in the magistrate division, the withdrawal of files, rules on the clerk's office and orders by the clerk, the selection of the master jury list and master jury wheel, the selection of the jury panel, qualifications of a civil mediator, and registration of private civil litigation evaluators. These rules have not been changed. They've simply been moved from the civil rules to the court administrative rules. Under the Court Administrative Rules, Rule 32 is records of the Judicial Department. There's several amendments to the Rule 32 that are effective July 1. Subsection G of the rule provides that certain records are confidential and exempt from disclosure. And it also says that willful or intentional disclosure of these records can be treated as contempt. Well, however, under that rule, there are certain cases or instances where disclosure of the record may be either explicitly or implicitly authorized by Rule 32 itself. So one of the clarifications makes it clear that the disclosures that may be treated as a contempt of court are those that are not otherwise authorized by the rule. Subsection G5 under Rule 32 provides that arrest warrants are exempt from disclosure while bench warrants are not. The terms arrest warrant and bench warrant have been defined to clarify this provision. An arrest warrant is defined as a warrant issued for the arrest and detention of defendant at the initiation of a criminal case. A bench warrant is a warrant issued for the arrest of a defendant who has already appeared in a criminal action. It includes a warrant issued for failure to appear, for violation of conditions of bail or release, or for a probation violation. The wrong designation on a warrant as set out in this rule results in the entire case file being inappropriately sealed if the warrant is outstanding. So hopefully courts and prosecutors are going to really pay attention to this definition and make sure they title their warrants appropriately. Subsection J of Rule 32 has also been amended. It deals with the sealing, redaction, and opening of records, and it's been revised in two aspects. First, the subsection has been divided into subparts, which is hopefully going to make it easier to read. Second, since Idaho is moving into a period where some courts are going to have fully electronic case files and some are going to have paper files, the rule's been revised to provide clearer procedures for sealing and redaction of records in both settings. As Idaho moves to electronic case files, clarity was also needed to make sure who is the custodian and custodian judges of electronic case records in each county, and who's the custodian and custodian judge of the statewide case management system. Subsection J has been amended to provide that the administrative director of the courts and the chief justice are the custodian and custodian judge of only the statewide case management system. Rule 56 in the administrative rules is on coordinated family court services cost recovery fee. That rule has been amended to allow a partial waiver of fees by family court services, and that's in order to be consistent with a statute that does permit partial fee waivers. Under the Idaho criminal rules, in accord with the amendment to Rule 32 I just mentioned to clarify the difference between an arrest warrant and a bench warrant, there were several criminal rules that were also amended. Rule 4 is on arrest warrant and summons. The word arrest was added to describe this warrant. Rule 5.3 is on initial appearance on probation violations. The amendment clarifies that the warrant for a probation violation is a bench warrant. Rule 46 is on bail or release on own recognizance. The rule was amended to reflect that the warrant referred to in this rule is a bench warrant. Rule 44.1 is on withdrawal and substitution of counsel. The rule now specifies that the court, in an order of appointment of counsel, may state at what time or upon what event the appointment terminates. For example, after the period for a notice of appeal has ended. Thus, as clerks, you need to be aware that the appointment of counsel could automatically expire without a separate court order upon the occurrence of a certain event or after a certain amount of time. Thus, you're going to want to confirm representation before sending notice to counsel, and this is especially important when you have a probation violation. There's also a new subsection on substitution of counsel that allows for notice to the court rather than leave of the court for substitution of counsel. And it specifies that if a new attorney appears in an action, the action shall proceed in all respects as though the new attorney of record had initially appeared for that party, unless the court finds good cause for delay of the proceedings. Rule 46.2 is on no contact orders. The reference to victims in this rule was changed to protected persons, as a no contact order is not limited to just protection of victims. It can be issued to protect others, such as witnesses, a co-defendant, or a reporting party. The change is also more accurately reflects the statute, which says that an order forbidding contact with another person may be entered. Rule 54.17 is on appellate review, and again, this is going to be a district court reviewing a magistrate court decision. If a district court on appeal remands less than all the issues back to the magistrate court, a problem can occur on appeal if the magistrate tries to take up that case on remand and then an appeals are filed to the Supreme Court. So then you have a case going in two different directions at the same time. So it was amended the same as the civil rules of procedure. There's a provision that requires the clerk to issue a remediator to the magistrate after the time for an appeal has expired if no appeal is filed to the to the Supreme Court, It advises the opinion is now final and the magistrate may actually proceed on remand. If an appeal is filed with the Supreme Court, then when the Supreme Court or the Court of Appeal has issued their opinion, a remediator will be issued to the district court, the one that initially heard that case on appeal from the magistrate division, and a copy of that remediator will be sent to the presiding magistrate. On the Idaho Rules of Family Law Procedure, there were several amendments that are effective July 1. Rule 201 on commencement of action. Subsection C is on proceedings to modify child custody, support, and maintenance. It was amended to expressly permit a proceeding to modify custody or support to be initiated by stipulation. Before, the rule provides that a petition has to be filed, but the court often sees modifications that are filed by stipulation without a petition, and so the amendment ratifies that practice, and that was also the reason the filing fee schedule was amended. Rule 207 is on documents, caption, name of parties, language, abbreviation, numbers. This rule was amended to reflect the changes that are now in Civil Procedure 2, which was formerly Rule of Civil Procedure 10, about what information the parties are required to put in their pleadings and in the captions. Rule 720 is new on brief focused assessments. This new rule authorizes the court to order a brief focused assessment in child custody cases, which is something less than a comprehensive parenting time evaluation, and when that evaluation is not needed or warranted in the case. The rule distinguishes between a brief focused assessment and a parenting time evaluation, and further defines the scope of the assessment to just a limited number of issues, the qualifications of assessors by making them consistent with the people who can perform parenting time evaluations, and the procedure for the appointment. A request for a brief focused assessment under this rule could be presented to the court by either motion or stipulation, and remember, this report is exempt from disclosure in Rule 32. Moving to infraction and misdemeanor rules, you should be aware that there are a number of new forms that were adopted for infractions and misdemeanors. This was with the goal of having these forms be uniform in the Odyssey system. Both Judge Box and Judge Williamson, who were with the magistrate judges work group and the district judges work group, sat in on some of these meetings, and their input was involved. Infraction Rule 8D, there is a new form for default judgment. It's been updated with clearer language and a more complete advisory. In Infraction Rule 10B, there's a new updated form for the notice of non-payment and non-compliance with an infraction judgment. In Infraction Rule 10D, the form for receipt and notice of payment was deleted. The clerk is still going to issue a receipt when someone pays it, but language about mailing it was deleted since it may be paid online in some cases. The rule did say payment shall not be mailed to the Department of Transportation. That's been changed to say a copy of the receipt will be transmitted to the Department of Transportation. And it was the understanding of the committee that this was already being done electronically, so that's what that language refers to. Misdemeanor Rule 8B, there's a new updated form for the deferred payment agreement. In Misdemeanor Rule 9.1, there are several new forms. There's a new form for the order suspending driving privileges that can actually be used for both misdemeanors and felonies on a finding of guilty. It's been updated with more complete information for the defendant, and it's much easier to read. The certificate of service states it's been transmitted electronically to the Department of Transportation, but again, it was the committee's understanding that that was already the practice and that was being done automatically. There are also new forms for the notice of penalties for subsequent violations and a temporary restricted license, which again, that was designed to be used for felonies as well as misdemeanors. And there's an affidavit, a new affidavit of refusal. The affidavit is actually a form used by police officers. The form for probable cause affidavit was deleted. Again, that's a form used by officers, and every police agency and law enforcement agency has its own form of affidavit. In Misdemeanor Rule 9.2, there's a new form for the order suspending driving privileges under Idaho Code 188002. This is for refusal to submit to evidentiary testing. Again, the certificate of service states has been transmitted electronically to the Department of Transportation. And you should note that language about the driver's license being seized has been deleted because that's no longer the practice. The officers don't do that and the clerks don't do that. On the bail bond schedule, we only have one new bail bond. That's for a fuels tax violation. It's Idaho Code 632450, and the bond amount is $382. The following amendments to the Idaho juvenile rules are effective July 1. Rule 19 is standards and procedures for commitment to the Department of Juvenile Corrections. The new rule seeks to address concerns that criteria for commitment of juveniles to state custody lack definition and judges had too much discretion in applying the existing criteria. The new rule seeks to base commitment decisions on a more evidence-based risk analysis, needs analysis. It eliminates the distinctions between misdemeanor and felony criteria and reduces the number of criteria to 4. Per the amended rule, a juvenile offender may become eligible for commitment to custody if the juvenile's prior history or charged offenses contain certain underlying facts, and those facts are set out in the rule, and again, there's 4 of them. The rule also states that prior to disposition on any offense for which a juvenile offender may be committed to the department, the court shall order that a screening team convene to determine whether or not the actual risk posed to the community by the juvenile offender can be addressed in a community-based setting, or whether the risks posed are such that the juvenile needs to be within a secure setting. The rule provides the screening team shall have a detailed history of the juvenile and what specifically that must include. Prior to issuing an order of commitment of a juvenile to the Department of Juvenile Corrections, the court shall make findings on the record as to the underlying facts and circumstances that were relied on in making the decision, and the specific facts relied on to determine that a community-based alternative was not appropriate. The amendment also adds new language stating that a juvenile under the age of 12 shall not be committed to the Department of Juvenile Corrections unless the court finds there are extraordinary circumstances, and the court may not commit a juvenile under the age of 10 to the custody of the department.